Good morning, everyone. I, Nitin Garg, would like to welcome you all to the third session of National Webinar on Career Awareness in Legal Globe, organized by Youth Parliament Society, Law College Dehradun, faculty of Uttaranchal University. I would like to welcome our guest speaker, Mr. V. Raghavan Inbavijayan, International Arbitrator and Managing Partner at KFCRI. Honorable Dean, Law College Dehradun and Officiating Vice Chancellor, Uttaranchal University, Professor Dr. Rajesh Bogna sir, Honorable Principal, Law College Dehradun, Professor Dr. Poonam Rawat ma'am, Honorable Chairperson, Youth Parliament Society, Dr. Rajit Sharma sir, and I would like to acknowledge President, Vice President, and members of the Youth Parliament Society, and welcome all the fellow attendees. Now, I would like to introduce the guest speaker, Mr. V. Raghavan Imbhavijan, International Arbitrator and Managing Partner at KFCRI. He persuaded law from Dr. Ambedkar Law College, University of Madras, and started practicing litigation in Madras High Court. His enthusiasm towards ADR diverted him to being an whole-time arbitrator since 2001. He is currently managing partner at Corp Global. He has proceeded as a sole arbitrator in over 300 domestic cases and commercial arbitrations and 14 international arbitrations, and foreign director in Sub-Council China. His key areas are international commercial arbitration, maritime arbitration, IPR, construction disputes, banking disputes, security market and investment disputes, sales of goods, and domain name disputes. He has been a member arbitrator in International Center of ADR, Ministry of Law, Justice, and Company Affairs, ICA, ICC India, and CIDRA, IIM Bangalore, and various other national and international arbitration institutes. To add up, he is the co-founder and former secretary of CNIAC and ICCA. UK has listed him in 2008 edition of Who's Who of Commercial Arbitration and has listed recently in India's Lawyer 45 under 45. In addition, he is promoting ADR by various books and providing training courses on ADR in chambers of commerce and conferences worldwide. Now, I would request Honorable Dean Sir, Law College Dehradun and Officiating Vice Chancellor Uttaranchal University, Professor Dr. Rajesh Bogna sir, to kindly address the gatherings.
Thank you, Nitin. On the occasion of this national webinar on career awareness in legal globe, on the third day of this webinar, today's keynote speaker, Mr. V. Inbavijayan, Principal of Law College Dehradun, Professor Dr. Poonam Rawat, Chairperson of the Society, Youth Parliament Society, Dr. Rajesh Sharma, President, Secretary, and all the office bearer of Youth Parliament Society of Law College Dehradun, and all the participants from Uttaranchal University and all other universities. And of course, today's host, Mr. Nitin Garg. I am taking this privilege to extend my greetings to all of you. And also, it's my proud privilege to welcome you on the behalf of Uttaranchal University and entire Law College Dehradun family. So you all are welcome in this national webinar. My dear friends, as this webinar series of webinars are being organized, particularly on the career awareness in legal globe, we understand that today's series of avenues are open for the law graduates. But when they choose to practice, then they have to either to practice in court of law traditionally, or they may opt sometime practice through alternative dispute resolution system. Now all over the world, the concept of non-litigating lawyers is also increasing. So when we see ADR, the first thing which comes to our mind is arbitration. No doubt, with the passage of time, now arbitration is also stepping into the shoes of litigation. And with so many gray areas, usage of section 34, etc., we are thinking that what is the scope and what is the practice of ADR and what will it be in future. So clarify all this doubt and give you the vision of these areas for law graduates. Today we have with us Mr. Inbavijayan sir. As we have seen his profile, I think in arbitration side, there is not even a single spell which is left. He has experience in all the way. I am highly satisfied and happy to see him on ICADR, since we both are life member of ICADR. So today I am in fact highly satisfied and see Vijayan Saab you here. So without taking much of the time, once again I welcome you on the behalf of Uttaranchal University family and entire participant. You are most welcome.
Thank you.
And in advance, since we are the co-members in the apex body of the country, I invite you in Law College Dehradun, Uttaranchal University, whenever the situation permits, please accept my invitation in advance.
Surely, sir. Sure.
So once again, most welcome. Thank you so much. Over to Nitin Garg.
Thank you, sir, for your humble words. Now, I would request Honorable Speaker, Mr. V. Raghavan Inbavijayan, to start with the session.
Yeah. Thank you, Nitin Garg. First of all, it is really a great honor to be before the greatest audience. There's a law students along with the Dean of the Law College Dehradun. It was really a surprise that I have met a colleague of ICDR. I think now I could remember Professor Rajesh, because I was in the initial period itself when all the chief justices of the relevant high courts they had a meeting with the chief ministers and they created the ICDR. Initially, a body of governing councils were established. I think from the inception of ICDR in our country, we were together promoting the concept. And particularly ICDR, under the aegis of Ministry of Law and Justice, which is the pioneer of all these arbitration activities, at least as Dr. Rajesh was highlighting that the way the alternative mechanisms going to predominantly dominate the at least the commercial litigation. Now we are happy as the ICDR members, we are very much happy that this message is really reached to the law students. This is really reached to the society at large, as well as this is reached to the entrepreneurs. Ultimately, the entrepreneurs are the persons who are going to be benefited, wherein we all are going to be a catalyst. Our role is just a catalyst. But to be an effective catalyst, I think now the Law College Dehradun, along with under the guidance of the Dean, sir, the principal, as well as the Youth Parliamentary Society, has given us the opportunity to share about what is the nuances, what is very interesting about arbitration. That's all about. Whether it is going to be the scope or practice, what is very interesting, why people are now going towards arbitration or other ADR mechanism. Okay, with this few introductory words, I like to just go into the, what you can say, the takeaway for this lecture. First, what we are going to do, what is the role available for law students, young lawyers to get into arbitration? A general understanding is that if a person graduates from a law college or the fancy law schools, what we have now, the national law schools and the other institutions, it is very clear that we have to be a constructive person, we have to be a responsible person, we have to be a harmonious person. These three qualities are very much required when we graduate from any law institution. But when we are just going to apply all these qualities, even though many people won't like these qualities, but as lawyers who are noble professionals, we need to have that quality. Because the history says a different notion about our freedom struggle. In the freedom struggle, every leading personalities happen to be a lawyer or with some legal knowledge, whether it is a father of nation or the first prime minister, all had the legal knowledge. The legal knowledge was an asset at the time when we fought or we got the freedom from the British colony or the British India. Now, having said that, the era has changed from the values of independence, from the values of governance, from the values of judicial, that is the pillars of democracy. Now we are shifting into the commercial world. Since the reforms, the globalization, the liberalization in the beginning 80s, wherein we happened to look into the GATS, the Uruguay rounds, the WTO, creation of WTOs, the world has changed. Not only the world, even the regions, every regions have started changing. Where is the question of the democratic value? We do have, but when it comes to the question of the value of the human rights, the value of public international law, the value of any other legal principles or the law which is deemed to be substantive and procedural, all of a sudden there was a change, paradigm change, that this world is all of commerce. The new world order, which was after the Second World War, which was into the public international law, has become very clearly that it is all commercial. It's a new commercial order which has evolved after this prominent reforms, what has happened. This commercial change also affected the legal professionals. As lawyers and law students, what is significant about this arbitration? How it penetrated and now it is dominating the entire practice. To my experience, it is very simple that the beneficiaries, that is the litigants, who are quite worried about the cumbersome process, what's happening in the courts. That is the only thing. When you just start your legal practice litigation, because I prefer to be a litigating lawyer. I started my practice in the High Court. I was happy doing all my practice in the trial courts. I enjoyed the enforcement of Code of Civil Procedure Code. It's very clear. The CPC is a wonderful, marvelous legislation which is so well administered and monitoring and managing the courts in India. The experience what we are getting in the court litigation, we can't get it in any way. But now, the ultimate beneficiary, that is the litigants or the masters. The litigants have to have the disputes resolved in a reasonable time, in a reasonable manner, in a reasonable cost, and with a reasonable flexible procedures. All these are ultimately the expectation of the litigants. The litigants' expectations is not that the interpretation of statute, wherein the lawyers are unique from any other professional. We know how to interpret the statutes, and the courts are there to test the legislations. Perfect. But as a litigant, they are quite worried about their dispute alone. What is going to be the outcome? How our dispute is going to be resolved? Here, what is the answer for them? If it is going to be a normal personal issues coming under the personal laws, we have the well-established court system wherein it starts from probate, a succession, a probate, it goes to family disputes, a family court, it goes to various levels of courts, the trial courts, special tribunals which are constituted to deal with the personal laws. When it comes to tax dispute, we have a lot of tax tribunals, the tax authorities, the commissionerates, all those are dealing. When you come to the latest component of anti-dumping, the competitions, we have a lot of commissions, tribunals established. Likewise, for various categories of litigation, we do have certain tribunals, we do have certain legal system, the courts. But when it comes to commercial contracts or a contract which is based on a commercial transaction, we don't have any other specialized tribunals. We only have the courts. At least now, after the 2015, we have the commercial courts. We have to wait and see how it is going to be effectively utilized by the litigants. But keeping apart that, the courts have certain ill effects, which is unavoidable and which is not the responsibility of any stakeholders. It is the procedures. The procedures are very well available for all the parties, the advocates, the judges, as well as the appellate judges. We have a lot of procedural aspects. These procedural aspects might lead the litigants to having a notion that, oh, litigation is time consuming. It might even see the next generation. Sure, it is very clear. When I started as a lawyer, the Madras High Court, there was a trial case because Madras High Court has original side, wherein the trial cases also comes to the High Court. I happen to assist my senior because we don't have a law firm. We have a concept of senior counsels wherein we work as junior. In that, I happen to deal with a case which was filed in 1954. Imagine the third generation is now dealing with that case. What is the takeaway? What is the benefit the litigants are getting fighting for a long time with all these procedures and ultimately ending up in the apex court? Where is the alternative for it? The alternative is there. Now we have, after the globalization and after, I think very well all would be familiar with the Arbitration Conciliation Act 1996, which is the base for arbitration. Once this 1996 arbitration law was enacted, the entire litigation jurisprudence changed. Now we are, a long period has gone. It is around 24 years. It's a quarter of a century we are reaching, wherein this arbitration started seeing the fruit. The fruit wherein we are the farmers, the lawyers, the law students are the farmers who are going to just produce and effectively produce this particular product, that is arbitration, and take it to the litigants. The litigants have to get that benefit. Now, as law students, what might be the roles? What are the available roles? What is the scope for law students in arbitration? It's very simple. It is not too much, just four. What are the four? The first one, the law student, as a normal, any diversified professional, they can act as consultant, a legal consultant in arbitration. Then comes the question, what might be the role of that legal consultant? Very simple. The legal consultant is a person who just prepare and deliver the basic document for that commercial transaction. And in that document, a smartly a person, a law student, a young lawyer, if he just incorporate the arbitration clause, that change the entire applicability and enforcement of that particular contract. Draft a contract, that is the normal work of a consultant. In addition, if you incorporate an arbitration clause instead of a court jurisdiction clause, surely the matter has to go to arbitration. This is the first step of a law student. Act as a consultant to draft an arbitration clause or an agreement. If the client is an MNC, your fees is phenomenal. All law students would be happy that if you are going to get a fees of a reasonable a lakh for drafting an arbitration clause, INR 1 lakh I'm saying, it is factual, it is real. The parties are ready to pay such a fees because the parties have to be properly guided to which forum we are taking the dispute. It is all about forum shopping for them. If we as consultant, if we can guide them, the first thing we have to draft an effective arbitration clause as a consultant to be incorporated in that contract. Do that job. That is the first job. You are entitled and it is a great avenue for you. No need to worry. You need not wait for 4, 5 or 10 years to be a consultant. To be a consultant, the day when you are graduated, you are eligible to do it. Secondly, you can be a counsel. Your future advocates, you can be a lawyer, corporate lawyer. You can be engaged in some companies as in-house counsels. Now we have a fancy caption that legal counsel, associate general counsel, associate managers, general counsels, head legals, vice president legal, senior vice president legal. All these are jobs normally based on the experience of the lawyers. You enter into the corporate world. So much of role is there as counsel. But when it comes to arbitration, there is also a significant role of a counsel. That counsel is termed to be an arbitration counsel. Simple. Parties, the litigants, are facilitated in the arbitration process with the help of these counsels. The lawyers, the law students, young lawyers or senior lawyers or associates of law firms can represent the parties or the litigants in arbitration disputes wherein we can appear as authorized representative of the parties before the arbitrators or the arbitral tribunal. This is the second role. It's a wonderful role because it is end-to-end, like an end-to-end encryption, what we have, whether it is a Zoom meeting or whether it's a WhatsApp. We call that the confidentiality, the privacy is maintained by end-to-end encryption. Likewise, an arbitration counsel is a person who safeguards the rights of the litigants from the invocation of the arbitration till the enforcement of the arbitration award. The entire process is being managed, monitored, administered, as well as facilitated by that counsel. This is the second role. Third role. Interestingly, once you do a lot of consultancy work and once you are involving in many number of cases as counsel, you will be considered as expert. Very simple. I think some law teachers would be happy that if they write a blog, if they write an article, if they write a scholarly article, the society and the readers would start understanding those people to be expert in a particular area of law. Whether it is IP law or whether it is going to be a tax law or the labor laws, any laws, we can be specialists, experts. In arbitration also, once you people get involved in a lot of consultancy work, counsel work, you will reach to the level of experts. Experts also have an effective role in arbitration. Fourth is deemed to be the peak of the arbitration process. What is that peak? It's very simple that you people are much eligible to sit as arbitrator himself or herself. The role of an arbitrator can be taken or well equipped by a person who possesses legal knowledge. A person who is possessing legal knowledge is the best person to arbitrate, preside as an arbitrator. And now, very interestingly, even though when I started in 2001, it was not like that. I was very few lucky person to get a role of an arbitrator quite early, hardly when I was 24 and a half. I got my first appointment as an arbitrator, but it is not like that. After a long period, it changed. For the past 20 years or 19 or 20 years, it was the entire role of senior practitioners, retired judicial officers, retired judges of the apex court or the high courts were considered as arbitrators. Now, it is not like that. Last year, in 2019, in the arbitration law, there was a major change, a revolution brought in by way of an inclusion of 8th schedule in the Arbitration Conciliation Act. I think when you just get back after this lecture, have a look on that 8th schedule. 8th schedule gives an opportunity for you people, whether you are going to practice or whether you are going to be employed in any public sector undertaking or whether you are going to be employed as lead counsels or legal counsels or general counsels. If you cross 10 years in your career, then you will be eligible to act as an arbitrator. Having said that, it is not only for us, a new avenue is being given by inclusion of this 8th schedule. Along with you, a person with engineering graduation, 10 years, post educational qualification, 10 years, they are also eligible. A company secretary with 10 years also is eligible. A chartered accountant with 10 years also is eligible. Any graduate, very interestingly, any graduate in the field of specialized areas like telecommunication, intellectual property, labor law, all are eligible. Now, diversified group of professionals with post educational qualification 10 years, that is normally when you put your CV, it is like 10 plus experience. If you have this 10 plus experience, obviously you are eligible to act as arbitrator. It is not my version, it is a version of the law. This is very common, but we have a slight advantage. Law students or young lawyers have an advantage. For another 10 years, obviously we have the law background. For another 10 years, once after completion of 10 years, when we venturing into the arbitration market as arbitrator, the other 3, we need not wait for 10 years, but at least for to sit as an arbitrator after 2019 amendment, it is that we had to wait for 10 years. No need to worry. After 10 years, you are the first person to be in the priority list to get that role. How? This answer is very simple. In the 8th schedule itself, there is an additional conditions or norms have been provided for a person to be qualified and experienced to sit as an arbitrator. What is that? The prospective arbitrator, whether you or I, assuming that we are crossing just 10 years, a prospective arbitrator should be conversant with the Constitution of India. We have to appreciate our institutions, because our institutions teach us the Indian Constitution. As law graduates, we have to familiarize Indian Constitution. The first bottleneck is cleared. We are conversant with Indian Constitution. Second, we have to be familiar with arbitration jurisprudence. Surely this 10 years, we would have acted as either consultant or counsel or expert. We also can satisfy that criteria. Third important thing is that we need to have some experience in arbitration or managing disputes. All the 3 makes us in a better position to take up the role as an arbitrator. These 4 roles are very, very interesting roles. Acting as consultant, appearing as counsel, taking the role of expert, and eventually sitting as arbitrator. This is very common. You can just look into any literatures and you can find these are the common scope in arbitration for law students. But There is another one interesting component which is now termed to be tribunal secretary. This tribunal secretary is not normal like tax tribunal or a motor accident tribunal. It is arbitral tribunal. The arbitrators who are deemed to be considered as arbitral tribunal need to be assisted by some individual. That individual is termed to be now as a tribunal secretary. This is the greatest opportunity for graduates, law graduates, from the day one of their enrollment or complete after the graduation they can take up. What is this role? How to just venture into this role? Perfect example is my own personal experience. I graduated in 1997, and after that 4 years I was into the commercial litigation as well as general litigations in the courts. 2001, when I started acting as an arbitrator, fortunately for some small claims, some parties approached me and appointed me as an arbitrator. I was still kept in dark. How to proceed further? I got my first appointment, but after that, how to continue? How I can just make me available in this market to be acting as arbitrator? Because I can't just go to straightaway counsel. I took the approach in a different way. Normally, traditionally in villages, instead of touching the nose, it's very common to touch the nose like this. But I touched the other way. It's very hard to touch. But fortunately, I got that opportunity. I started as arbitrator. Being an arbitrator, going into as a counsel, created a lot of conflict of interest. I was quite in an impasse situation, how to proceed. At that point of time, very interestingly, I was invited by one former Supreme Court judge who was doing a lot of arbitration cases. He was having many cases as sole arbitrator, as well as he was dealing with 3-member tribunal as presiding arbitrator. Those days they were called as chairman and umpire. Now that important third person is considered as a presiding arbitrator. When he just invited me, he just asked about my exposure in arbitration. I just shared with him that I sat as an arbitrator. He was astonished. He told that how at this young age you act as an arbitrator. I simply told that it's just a fortune for me. It is a rarest opportunity. Just a basic some research I did. Based on that, some parties approached and I was appointed. He guided me. He told that, okay, fine. Somehow you just entered into the arbitration field, whether knowingly or unknowingly, with interest you just approached and you entered. Now you have to carefully take this as your profession. To start with, what he told that he asked me to act as a assistant at that time. That was, I think, in 2004-05. He told that you act as an assistant, you come with me, you do all the secretarial work, and you just help in all the arbitration documentations, dealing with the proceedings, recording the minutes, and even help me in drafting the award. That was the first request he made, and I simply started, okay, what is that? Even though I sat as an arbitrator, why can't I assist? Because that man was a person of quality and he was in the collegium of the Supreme Court, a former Supreme Court judge. He's no more. And that person gave me that first opportunity to assist. I enjoyed not only with the work, I enjoyed really with a good remuneration. To be happy, I have to share that in 2004, that is 15 years back, when I was appointed as assistant to him, he paid me 10,000 rupees per sitting. It's a wonderful fee and it's a good starting for me. It was much better than what I got as an arbitrator. As an arbitrator, I was paid a lump sum of 5,000 rupees when I started in 2001. Both the parties combinedly, it was sharing of 2,500, 2,500. I was very happy. 10,000 was a big money for me. That too, assisting an arbitrator. Later, it continued, and he just had 7 big arbitration cases and complex arbitration cases where he sat as sole arbitrator. There, in addition to the remuneration, I learned a lot. I learned how to draft effective procedural orders. I learned how to draft the minutes of proceedings. I learned how to manage the proceedings. Very interestingly, in arbitration, the arbitrator has to manage, control the proceedings. I learned from that judge when I was assisting. And finally, very, very interesting, only role of an arbitrator is to issue the award, draft the award. Even though I have drafted an award earlier, that was with my simple knowledge. I think law students would accept cut, copy, paste. I just literally went into the journals. At the time, there was Raj, they call the recent arbitration judgments. I took those and literally what they have drafted, I just made a compilation of various judgments. I drafted an award. Fortunately, it got enforced without challenge. When I was sitting as an assistant to that arbitrator, I got to know the real art of drafting an award, real art of drafting a judgment. That experience molded me a lot to be an effective arbitrator. Because to be an arbitrator is easy. If you have, I think even Professor Rajesh Baguna would also accept that as a senior person in this field, he can be considered as an arbitrator to be appointed. But when he sits as an arbitrator, he has to forget about all the aspects of the knowledge what you have gained. Whatever experience you have, whatever you learn, you might be master in a particular subject. You know the reality. You know how to interpret that particular dispute. But as an arbitrator, you have to be just a good listener. Just keep our mouth closed and just observe. Literally, you have to be like this. You can also, some arbitrators literally enjoy the time sleeping. That we should not do. But as a prudent arbitrator, we have to be a good listener. A lawyer is not a good listener. Please understand, a lawyer wants always what he is going to speak, he wants to hear. He always wants to speak, he always wants to interrupt. He has to just literally go into all these nuances. He has to go into his nuances in a calm nature, understanding all the happenings in front, in back, and side. As rightly in historical documents, what has been said, we lawyers have to have an eyes behind the head also. Whether it's going to happen or not, we are not sure. But as an arbitrator, we have all those qualities also. We need to have or possess those qualities. When I assisted to that arbitrator, I learned a lot. I learned this skill of there was some disturbance. When we just go into all these roles, now it is 5. 1 is consultant, 2 is counsel, 3 is expert, 4 is arbitrator, and 5 is now, which is called as a tribunal secretary. All these 5 roles are very, very effective roles for a person, particularly a law students, to commence. Now, going into the practice, what is the arbitration practice is all about? What is significance about arbitration? The major significant aspect in arbitration is the sector-specific arbitrations. Arbitration as such, many would understand looking into the books that it is commercial arbitration. And if you look into the BARAC, you can find that there is a term called international commercial arbitration. It is not confined with these. It is like an ocean, 360-degree opportunities is there. What are those? Very important, the sectors, what we have is, one is international commercial arbitration, The next one is construction arbitration. Then we have maritime arbitration. Then we have the intellectual property rights arbitration. Then the securities market arbitration, commodity market arbitration, domain name disputes arbitration, agriculture arbitration, animal husbandry arbitration, consumer arbitration. Consumer arbitration is not there in India, but in jurisprudence in civil law countries we do have. Best example, in US we have consumer arbitration. We have sports arbitration, very interesting development now. And we also have some other arbitrations, and very prominently what we can see in the newspapers, that is investment arbitration, that is investor state arbitration. The list goes on, but whatever I have just mentioned are very interesting sectors wherein we have a lot of opportunity. All these sectors, whether it is going to start an international commercial arbitration, it's very simple. International commercial arbitration, the practices dealing with cross-border transaction. If the same, if you go to US, it is called as transnational arbitrations. All these eventually bring in an opportunity for neutral country arbitrators. Assuming that if you want to term an arbitration to be international arbitration, we need to have one Indian and another foreigner. Very simple. There is an export trade. Indian party is exporting iron ore to a Chinese party. These two parties enter into a contract. They have a dispute. The contract is drafted by you. In that contract, you have included an arbitration clause, and you have mentioned arbitration to be happening in India. Very simple. During the execution of that contract, the completion of that trade transaction, there is a dispute. A dispute, for example, you can just take, there is a quality dispute. The Chinese party is raising a serious issue that the iron ore supplied is not to that standard what was agreed in the contract. All the terms and conditions clearly mentions that where the breach has happened, the breach is identified, and the Indian party has done the breach, the respective quality is not supplied. Now it is a dispute. This dispute has to be taken to arbitration, where we have to take. According to the contract, what you have drafted, it has to be taken only to India. Okay, fine. There is no disagreement between the parties. We are taking to India. The Chinese party is coming to India doing the arbitration. First, the Chinese party as well as the Indian party have to appoint an arbitrator. Assuming that they have agreed for one arbitrator, whom they will appoint. As a Chinese party, he wants to appoint a Chinese national. As an Indian party, the Indian party would be inclined to appoint a Indian arbitrator, Indian national. There is no agreement. Ultimately, it goes to the court. And since it's being an international commercial arbitration, we are taking to the Supreme Court. In all these platforms, whether invoking arbitration or initially drafting the contract, identifying the breach, invoking the arbitration, and ultimately going to the courts to get that arbitrator appointment, our role is significant. Our role is significant as a consultant, drafting the clause, as a counsel or an advisor, legal advisor for that Chinese party or Indian party, we are helping them to invoke the arbitration. As an advocate, we are representing the parties before the courts, and we are going to get an arbitrator appointed. All these are our own domain. We can literally have a good scope. Now, the court is going to appoint an arbitrator. Now, the court has to cautiously appoint an arbitrator who is neither Chinese nor Indian. The court has to appoint a neutral country arbitrator. That is significant about international commercial arbitration. Now, a Sri Lankan or a Bangladeshi or a Nepali or any national can be appointed as an arbitrator by the Supreme Court. That is the law. Now, similarly, you forget about India. If the arbitration is happening in India, if the neutral country arbitrator, eventually we can't be sitting as an arbitrator. If it's a 3-member tribunal, at least for the Indian party, we can be the arbitrator. Indian party would appoint an Indian arbitrator, Chinese party, Chinese arbitrator. The neutral person might be a Nepali arbitrator. The same type of jurisprudence is also available in more than 75 countries. The law based on which the practice of arbitration, based on which we all are acting or taking all these roles, is also similar in more than 75 jurisprudence. That is, the base model law, unsettled model law for international commercial arbitration is adopted in many jurisdictions, wherein all these jurisdictions we do have a similar law. That means if an international commercial arbitration happens in example Sri Lanka, a neutral country arbitrator would be an Indian arbitrator. This is one interesting scope beyond counsel, consultant, expert, or even advocate appearing in the courts facilitating the arbitration process. Okay. Having said that, the other sectors like example, you can take a construction arbitration. What is significant? Whether we are suitable to deal with the construction arbitration to some extent, not totally, because it is purely on engineering, procurement, and construction. We call it EPC contracts. In EPC contracts, predominantly the best person would be engineers, a civil engineer, a structural engineer, an architect, a person who has been a former chief engineer, contracts. All predominantly it's an exclusive domain given to engineers, but still we have a good role as a legal expert, good role as an arbitrator, not the respective parties nominated arbitrator. We can sit as presiding arbitrator, because ultimately in an arbitration an award has to be given. An award is going to be tested by the courts, either enforcement or challenge. Both enforcement and challenge has to be done only by the courts. If the court is going to look into a particular aspect of an arbitration, it is very, very interesting that that arbitration has to be presided by a person with legal knowledge, predominantly advocate lawyers like us. This is some sectors. All these sectors, subject to your expertise, subject to your interest, you can just get involved. But how to approach? What is the skill required to reach this? The very interesting thing is that the skill might be like a moral science class, but what I have just prepared is very simple. We need to have a sense of strategy. We need to have an understanding of the commercial contracts. We need to have a knowledge and insight to create your own arguments. And also you need to have ability to express thoughts. We have much thoughts. All the thoughts should be expressed. It shouldn't be just like a graveyard. We shouldn't close it off in our brain. We have to expose. Our brain is much more efficient than a computer. Artificial intelligence, what is being spoken now, can just be an alternative to all, but not for a human brain. Because the codings, what has been given to the artificial intelligence or the robot, the computers, is all our brain. Our brain is matchless to anyone. That ability is there, but we need to express whatever thoughts we have. If we express, then we can be like the great man or the philosophers or the spiritual leaders. All express the thoughts. As lawyers, we are also capable to express our thought, but to be in arbitration practice, the best skill is that we have to possess the ability to express our thoughts. And most interestingly, we need to have a holistic approach to the disputes. That is the comprehensive approach to solve the problem. We have to effectively solve the problem. That skill we need. As a repetition, I wanted to highlight this very important, all these 5 points. We need to have a sense of strategy. We have to be always unique. We literally to be unique. Our uniqueness gives us opportunity. Our uniqueness gives a great scope in arbitration. Our understanding of the contract, We are capable to interpret the contract, but we have to understand the contract. Thirdly, we need to have the knowledge and insight to create our own arguments. We always want to differ from others. We have to argue differently. The right and left brain has to work differently for lawyers, and particularly in arbitration, we need to enforce this. We also need to have the ability to express a thought along with the holistic approach. All these five, interestingly, what I learned from that great gentleman as well as from various literature, that these are the skill and these are the approaches what we need to possess to be a good practitioner in arbitration. As a interesting tip, I think I have another 8 or 9 minutes. As an interesting tip or trade secret, I wanted to highlight some things for you, how to explore this opportunity. The scope is there, how you are going to explore. Exploration would be easy first if you can approach an arbitration institution. The beginning of the lecture and before that, the welcome address, what Professor Dr. Rajesh was mentioning about ICDR. ICDR is one of the prominent arbitration institutions in our country. Similarly, we have a lot of arbitration institutions spread over every metropolitan cities in our country. Even 2-tier cities nowadays have arbitration institutions. All these institutions is the best place for us to start. If you are not having or possessing all these qualities, extra special qualities, as advocates, we can approach these institutions and we can start with humble beginning. Humble beginning is taking internship. Taking internship in an institution, an arbitration institution, would make you familiarize on the subject. The theory, whatever you had reading in your college, it's based only on your examinations, only on the examination perspective. You have just looked into the theories. But when you just deal with an arbitration institution, when you approach an arbitration institution, you will start learning the case management skill. One thing you have to be very clear, in arbitration, we don't have a concept of like a registry providing assistance. In courts, we have that registry, an established registry which will guide the judges, which will guide the litigants, which will guide the advocates, which will guide the appellate jurisdiction also with all the works, the documentation till enforcement and depository. All the role would be done by the registry. But in arbitration, we don't have such infrastructure or an administrative assistance. To take this, institutions are developed. Arbitration institution does all the role similar to a registry for a charge. There is an administrative fee. That role makes the interns exposed or look into various components of how the arbitration works. All the administrative aspect of an arbitration could be understood by the interns when they take up an internship in the arbitration institution. Along with that, these specific arbitration institutions also have young groups. I started with all these young groups. Those earlier days I had only YIAG. It's called Young International Arbitrators Group, attached to London Court of International Arbitration. After that, there was Young ICA, that is Young International Council for Commercial Arbitration. Likewise, now you have MCIA, that is Mumbai Center for International Arbitration, young members. Likewise, we have many young groups, less than 40 are considered to be young group members. Switzerland also has, Sweden also has, and nowadays even Korea also is starting. And very interestingly, in our region, there is Young SIAC, that is YSIAC they call, Young Singapore International Arbitration Center. These groups bring in all these young enthusiasts in this field to get into arbitration. The only role of these group or the forums is to organize many lectures, 2 hours, 3 hours branch on meetings, short meetings, discussion forums, then fireside chats, Likewise, many regular happenings, it's all free of cost. Your membership itself is free. The pro events also free. You can go there. You can learn something new, something interesting in arbitration, and also you can have a good networking, effective networking when we just go to such events. Nowadays, these events are also happening virtually. Try to explore that. Arbitration is institutions the best place to start for young lawyers, at least in the present situation, because now the arbitration also has quite become competitive. It is totally different from what was that 2 decades before. You have to be constructively managing this competition. Start with arbitration institution. There are big number of database available. Interesting database is the Global Arbitration Review. It is called GAR, Regional Center for Arbitration. Have a look on that. And it is regularly updated. Every year it's updated. Look into it. You can find the institution and you can reach that institution, get some internship. It is not paid. Most of it's not paid, unpaid, but still it's worth taking those internship. Then you have to attend various conferences, seminars, and now the webinars. Whatever subject to your financial position, no need to worry. Most of the organizations are not charging much. You just go and approach these the forums where they are organizing the conferences. I think beforehand, one question came interestingly: what is the age limit to be an arbitrator? Some institution has an upper cap of 75. Minimum earlier, before the 2019, it was just 18 years, 18 plus. A normal natural person is eligible. Next, act as an arbitrator. This is a good avenue. It's a trade secret. Wherever, whatever the term I use the word assistance and assistant. But you people can now take up this role as an tribunal secretary. Many arbitration institutions are facilitating, or you also can just approach some leading arbitration practitioners and get into their arbitration cases and learn a lot. That exposure, minimum 1 year is sufficient for you to just do wonders in arbitration. Then you have to just find a good mentor. When I started, the judge was there. Along with that, I used to just look into a lot of YouTube videos and write to many leading arbitration practitioners. One among them was Dr. Gary Bond. I think many would be seeing Dr. Gary Bond of Wilmer Hale, a leading arbitrator. Many such arbitrators are there. Those arbitrators and arbitration councils, if you are lucky enough, they will act as mentor. And some institution also has some mentoring program, wherein some leading practitioners volunteer their time for mentoring. Try to reach and find one mentor and have a regular active networking with those mentors. Additionally, there are some people go for masters taking in arbitration, and there are some, it's not affordable to all. Even I didn't get that opportunity to take such masters because of the financial position those days. But still, we have a lot of opportunities locally also. Local masters also in India also, we have some masters which facilitate arbitration. Try that. Then I have some 4 to 5. I'll just try to complete. The next one, you have to be contributing literatures, and to begin with, write blogs. Writing blogs would make you well known in this market, that you are a person who is trying to explore arbitration. Write blogs like any other professional. Write blogs. Then you have to learn the contract drafting as well as how businesses work. Business is totally different because all these commercial contracts has business or business driven. It is all commercial. It is no way connected with all the legal nuances. It is all 2 parties entering into as a good agreement wherein they are complementing each other. That is contract. They are complementing each other to do a work. In that, we should not do a lot of legal interpretation. We have to understand why they entered into the contract, what was the basis for that contract, what is the actual background. Like a law commission member looks into all the situation, then only he drafts for the purpose. There should be a purpose. That purpose we have to identify. We as arbitration practitioners or future arbitration practitioners should develop the skill to understand or learn the contract drafting skill and how businesses work. Further, we have to look into the observations of the judgments reported in journals and reporters so that we can well equipped to draft a good arbitration award or understand the arbitration award. Further down the line, we have to look into the global developments of blogs. Many blogs are there. You have to write blogs as well as you have to look into various blogs which is available, and to some extent you can also get into moot courts. Moot courts are there. Then some competitions are there. Nowadays we have award writing competition. My good friend Ratan Singh has started an endowment wherein Ratan Singh's essay competitions there. I guess many essay competitions are there. Even in my own institution, KFCRI, we had an essay competition exclusive on arbitration. Likewise, many competitions and moot courts are there, but don't spend too much of time. Make a productive time and utilize productively, wherein some interesting components you can just do it. Having said all these are some approaches which some my own, some I just looked into some literatures wherein I found. But the best experience what as law students you have to possess or you have to procure to be a best person to explore the scope available in this arbitration is that you have to develop the passion to travel. Exception is this pandemic period. If you have the passion to travel, then you will be the best person, best suitable person to arbitrate. Explore, explore, explore. You have to travel. At least my passion to arbitration to some extent started because I wanted to travel. Entire earlier days, my childhood, I didn't travel. Then I wanted to see. My interest in history and geography wanted me to see many cities, many countries. Now I am traveling to all the places. I'm happy. But that passion led me to arbitration, and ultimately arbitration brought me to all the destination, important destination, wherein I just travel and I enjoy the culture, the legal culture, the local cuisines. We have to enjoy that also. As legal practitioner, we have to enjoy along with the society. To enjoy, have this passion with all these qualities or skill. Don't just look into the memories. It all comes with our own thoughts. What is the best thing? But those thoughts should be constructive thoughts. Have some constructive thoughts and look this arbitration. Whatever I just given are some basic component for you to explore. Try to explore these thoughts. And once you explore these thoughts, then the scope in arbitration is abundant. Normally there is a say, senior lawyers, when we start our practice, sky is the limit for the lawyers. Eventually now lawyers, when it comes to arbitration, there is no such. Outer space arbitration also is there. We do space arbitration. I think there is a very interesting professor, Professor Balakrishna Reddy in Nalsa. He does a lot into the aviation law. I'm happy to say, when some students of him might be watching, I'm happy to say that now the space arbitration also is available. We can just go beyond that. There is no limit for us to arbitrate. And if you can arbitrate, the arbitration was started actually from King Solomon, facilitating for two mothers, claiming the right of a child. Now we are the child. We have been benefited by arbitration. Now we have to effectively utilize what is available in this market, and we are ultimately bringing a harmonious society, and we are also facilitating the judiciary. Please understand, the judiciary is overburdened with lot of cases. The records, the statistics, what says is abundant, goes to crores. But I'm not going to the statistic. The only thing is that if you take the commercial disputes to arbitration, whether as a counsel or a consultant or as an expert, as an arbitrator, whatever role you are going to take, you are helping the judiciary. You are minimizing the burden of the judiciary, and ultimately the harmonious society is possible, and the litigants would get the result. The result of the litigant, whether they are going to succeed or lose the case, the satisfaction what they are going to get, that is the ultimatum for us. not to have a rebirth in this world. Thank you.
Thank you, sir, for enlightening us with your polychromic experience. With your permission, I would like to ask few questions on ADR.
Yeah. Yes, Mr. Nitin.
Sir, my first question is, what is the impact of LPG policy on ADR?
LPG policy.
Yes, sir. Liberalization, privatization, privilege.
It is very simple. The answer is, it is creating a good investment climate, and obviously arbitration is developing in a rocket pace because of LPG. There is no negative effect. It is all positive effect.
So there is another question. What happens if a lawsuit is filed despite an arbitration agreement?
If a lawsuit is filed with a contract having an arbitration agreement, eventually the lawyer of the other side has to bring to the notice of the courts by way of very common Section 8 application. In the Arbitration Conciliation Act, there is an provision, Section 8, which speaks about power to refer to arbitration by the court. That has to be invoked by the other party or his counsel in the courts, and eventually the court has to refer. The court can't say that I can't refer. The court has to refer because the arbitration jurisdiction prevails over the court jurisdiction. This is literally called anti-suit injunction. That application has to be made under Section 8 so that the matter will be referred to arbitration.
Sir, how do you feel the Arbitration Council will act or prove to be progressive step in development of institutional arbitration?
This is my answer is going to be truly personal. In my personal understanding of inclusion of Arbitration Council of India is going to bring exclusive career called arbitrator. And Arbitration Council is going to create a grading system for arbitrators as well as arbitration institution. This is going to be a parallel to, like in a personal note, as a bar council, wherein once we all graduate and get enrolled as an advocate, we are eligible to practice. Similarly, when we are getting enrolled or graded in the Arbitration Council of India, a career called arbitrator, which I started earlier in 2001, is going to be a realistic one.
Thank you, sir. Now I would request Honorable Dean, sir, Law College Dehradun, Faculty of Uttaranchal University, to give a vote of thanks. Sir, audio. Thank you.
Well, after this interactive session and so informative session and a talk by so experienced person in a very good manner, concisely, precisely, and in comprehensive manner, vote of thanks remains mere a formality. So let me tell you, it is said the experience speaks, and it is seen here in this delivery that the way Mr. Vijayan has taken the topic right from the beginning, how the paradigm change has taken place in this field. Earlier it was considered that arbitration is the work of retired High Court or Supreme Court judges only. But he has made it very clear that every graduate can go and take this field. So particularly for the law graduate, he has shown you the series of avenues, right starting from legal consultant, corporate lawyer, arbitrator, experts, and also tribunal secretary, and your own practice also. But what is important, what I could make out, and every student should follow that. The important thing is, and I usually share with you, we all are standing at a juncture. There are so many ways. And the question before us is, which ways to be followed? Sometimes we are confused also. Someone will say that after graduation, the best way to join civil services, some say judicial services, some say law practice, this and that, arbitration, this and that. At this point of time, I will share one quotation from Mahabharata. It is said, different are the Vedas, so are Smritis. There is not even a single sage whose views are not divergent with the others. Essence of dharma is very difficult to know. And best path is that is followed by the virtuous man. What I could make out of the speech of Inbavijayan, very honestly he has explained you have to search a mentor. It was his first mentor who has changed his entire life. So when you are in a doubt and you are confused, put your energy to identify who is the successful person. As the Mahabharata say, best path is that is followed by the virtuous man. सर्वोत्तम रास्ता वो है जो बुद्धिजीवियों ने अपनाया है. So now you put your energy to identify who is your virtuous man. I say, even if your father is your hero, he is a virtuous man. Just follow what path he has followed. Similarly, at like Mr. Inbavijayan has done, he has followed a judge. He has taken, that was the successful arbitrator, and he has given the best way to you how to explore these. Writing of blog, reading of blogs, internship with the top-notch institution like ICADR and IC and all. And these are the different ways how you can enter into this field successfully. With this talk, I can understand there were very few questions. It shows that the entire topic is clear. There was no question at all. Even I do not have any question. And I will tell you one thing. On 9th of June, Government of India through University Grant Commission has taken a step, and they see a vision to establish India as a hub for the conferences and conventions. And they have conveyed it to every university and institution of the country. Just give the possibility of organizing this type of conventions and conferences in your institution. If you have that infrastructure, let the entire country see it, and it should become hub for that, India. And before this, our Honorable Prime Minister has already announced that India should become hub for the arbitration. So We are also working on that line. We should think of that vision also, as he has given the possibility of international arbitrators also. So all these, the entire mirror has been shown to you by Mr. B. Inbavijayan. And with this, I thank you, Vijay Sir, from the bottom of my heart. You have given so informative vision to my student. Even my faculty members have joined you, and I have seen the student from different university of the country. So thank you very much, sir.
Thank you, sir. Thank you.
Now, I feel my duty, even if I do not thank the entire organizing committee. So we have on board Professor Poonam Rawat, who is head of the department and presently principal of Law College Dehradun. Thank you, ma'am. Thank you for organizing such a beautiful event with so eminent speakers. And Vijay sir, I will tell you that we have student bodies. We believe that youth are full with energy. So we wish to channelize their energy through these student bodies. And Youth Parliament Society is one of the student body here, which is responsible normal time to organize national, international events, elections, youth parliaments, mock parliaments, etc. But now in additionally, they had undertaken this responsibility to organize this webinar. So I will congratulate and thanks Dr. Rajesh Sharma, who is chairperson of the society, for organizing these wonderful events. Keep it up. Thank you so much, Sharma.
Yeah.
Now, the society is president Sahil Rajput and vice president and all the office bearer and Nitin Garg sitting before me as a host. Entire technical team, especially Abhijit and Rahul Kumar also, who is supporting them from outside, and lastly Youth Bar Association, who has facilitated them with this channel. So all our thanks. All students need my special blessing. God bless you. Thank you so much. Thank you, everyone.
Yeah. Can I say one, 2 or 3 words?
Definitely, definitely. It's my honor.
Yeah. Thank you. First of all, I have to thank very interestingly one of your student, Mr. Abhijit Kashyap, who was doing online internship, even though he can't spend too much of time because of the virtual difficulties. I have to thank Abhijit for facilitating and reaching this message to the society, and ultimately Professor Dr. Rajesh taking this and permitting me to be in front of all of you. Secondly, I am very happy that this such a society doing such a wonderful work, reaching pan-India, along with that some globally also outside. And from the student age itself, the building of confidence of people has been generated. That I'm very happy looking into this society. Thirdly, as a matter of information, as Dr. Rajesh was mentioning initially about ICDR, just in February 2020, I was there crossing your university. I was just crossing that bridge leading to UPS. I was there for UPS for a short present for a competition. And I was amazed looking into the structure, the architecture of the Uttaranchal University. Literally, I was wondering whether I can enter into that compound. I think now there is a platform created so that my next visit, when I am going to Haridwar or some pilgrimage, surely I'll have a drop into your university, sir.
You are most welcome. You are most welcome, and we'll be highly obliged and happy to see you here. Yes. Definitely, we will be happy to see you here.
Thank you.
Thank you.
Thank you, sir, for allowing us to conduct the session. Now I would like to conclude the session. Thank you.